Hey everyone, welcome back to the VSO Gun Channel. It's great to have you here as always, and thank you for watching. Today we're going to start you out right with some great news. The FPC, the Firearms Policy Coalition, is headed to the Supreme Court in the Vanderstock v. Garland case. That is the case that deals with the redefinition of frame and receiver by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and that's what we're going to be talking about here today. Real quick word from our sponsor. Quick service announcement for all of y'all. We have now 2 discount codes prepped up for you guys over at Mission First Tactical. One is for the all-day everything stuff, everything from their backpacks to their drinkware to the holsters to even the new translucent magazines that they just came out with. Really like the purple ones, by the way. And then a second code that is for everything that is getting ready to go away, about to be discontinued, the closeouts, if you will. Older backpack designs to their range bags, to their rifle cases, and even some of the larger drinkware items that didn't quite stick. That is going to be a rolling list that's going to change with time, but it's going to be like 50 or 60% off in many cases. So you can find all that information over at the affiliates page, and special thanks to Mission First Tactical for making today's video possible. Well, this is for all the marbles, boys and girls. Writ of certiorari was granted yesterday, 4/22/2024, and let's just scroll back down to see when this was originally filed. I like the way FPC does this because all of their cases are listed reverse chronologically, so you can just scroll back to the bottom. 8/11/2022 is when it was originally filed. And again, for those of you who have been following this super closely, I'll just give you a list of everybody involved in the filing for the Supreme Court. This is Defense Distributed, Polymer obviously Vanderstock, JSD Supply, Second Amendment Foundation, Tactical Machining's Firearm Policy Coalition, and Blackhawk Manufacturing Group. The reason this is important is, regardless of which case made it first, whether it was going to be the pistol brace situation, or whether it was the frame and receiver rule, or whether it's the who's engaged in the business of dealing firearms, et cetera, all of these rule changes that are meant to subvert the text of the legislation to gain more additional powers for the agency and thus the rogue administration that is controlling them. Whichever one made it first, all of them challenge one thing in common. Can you just change the definition of something without the consent of Congress? And that's what is really at the heart of this. Can they just change definitions willy-nilly to suit whatever means they seem to deem necessary? And the answer to that, we already know, is no, they can't. Because we've already seen this logic applied to 2 cases, at least 2 cases that I'm familiar with, dealing with the same thing at the EPA. And we cover both those cases that deal with, hey, can you just make up your own rules as you go along, or do you have to go get the consent of Congress to govern? Because you're not supposed to be governing. If we apply that logic through, I think that it's pretty easy to see where this is going to go, which is I'm pretty confident, and I think that everybody will agree. I'm sure that the people who have to present for the other side at the Supreme Court are quaking in their boots over this one, because I'm pretty sure that they're going to get their butt kicked on this one. I think they're going to get shellacked, pee-pee slapped, whatever you want to say, because you can't do that. Now, the question is, does it stop there? Because some of these have challenged on more than one grounds. More than one grounds. Is that English? More than one ground. Sorry. It's 5:30 in the morning. I haven't even finished my morning coffee yet or made it to the gym. So, more than one ground. So, again, can you change the definition? And if they're not allowed to change the definition, then all of those rules get invalidated. The premise of something set forth by the Supreme Court can be applied across the board, and any of those other cases that are waiting to hear something from the Supreme Court can then reference what the Supreme Court said, and then it provides controlling precedent. And I'm not a lawyer, so probably mixing my terms a little bit, but that's generally how it works. Is lower courts can be like, well, the Supreme Court said you can't do that, so in the future, if they try to do something like this, then they can rubber stamp that and be like, nah, that's not right, unless the Supreme Court finds some kind of flaw in another review. Does the Supreme Court stop there, or do they take a little bit more rope? So what we're going to do is look at the filings and determine whether there's any room in there for the Supreme Court to give us any more nuggets for future constitutional challenges. Reading now for the respondents, Defense Distributed Polymer 80 and Second Amendment Foundation. The Gun Control Act of 1968 was not intended to discourage or eliminate the private ownership or use of firearms by law-abiding citizens for lawful purposes. So Congress defined its keystone term, firearm, to cover an actual firearm and its actual frame or receiver, but not mere parts that might be manufactured into one. It thereby covers full-fledged commercial firearms without covering private gun making. A 2022 Bureau of Alcohol, Tobacco, Firearms, and Explosives rule redefines the GCA term, the Gun Control Act term, firearm, with a bunch of gobbledygook. ATF's new firearm redefinition makes the Gun Control Act cover more than an actual firearm and its actual frame or receiver. It goes well beyond full-fledged commercial firearms, deep into private gun making. The questions presented are: 1. Whether the Gun Control Act term, firearm, defined by this law, includes a weapons parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive under the new ATF rule. And 2, whether the GCA term firearm defined by this law includes a partially complete, assembled, or non-functional frame or receiver that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame and receiver under the new ATF rule. Reading now for Vanderstock, Adrian, Tactical Machining, Firearms Policy Coalition, and Blackhawk Manufacturing Group. Congress has defined a firearm, as relevant here, as any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive or the frame or receiver of any such weapon. Legal gobbledygook citation. Since 1968, the ATF has consistently treated this definition as encompassing finished frames and receivers. But in 2022, in a sweeping rulemaking, it redefined the term, including products it had never before considered firearms, because although they were not frames and receivers as such, they were designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver, or were sold as a weapons parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive, though they lacked a frame or receiver. The questions presented are: 1. Whether an item that is not a functional frame or receiver, but merely may be manufactured into one by a purchaser, is a firearm under federal law. 2. Whether a weapons parts kit may be considered a firearm even though Congress expressly excluded from its definition any weapons parts other than the frame and receiver, and the newly regulated kit's lack of a frame or receiver. Now, I'm obviously not going to read the rest of these documents to you because they're like 30 pages apiece. But I think just from the initial questions, without even getting into the substantive arguments beneath those questions, I think that we can easily see where the Supreme Court would pull another, well, text, history, and tradition of the United States type thing on this type of abuse of power. So I think my honest opinion is that they're going to get their butts kicked at the Supreme Court, and the whole process of, hey, we're just going to change what the words mean. And because we changed what the words mean, they can fit into the puzzle that we wanted them to fit in. But then on top of that, I think there is potential here for the Supreme Court to say, hey, this whole concept of you trying to regulate something outside of what the law expressly states is done. You need to go to Congress and get them to actually pass a law to give you the power that you want. I think that that's the direction that we see it going, but I want to know what you guys think about what additional nuggets do you think are possible for the Supreme Court to maybe sneak in there? Because we've seen it happen before, and I'm confident that we will see something like that before. Or do you think the exact opposite? Do you think that they will narrowly tailor their decision on this thing and this thing alone? Anyway, I'm out of here. I got more videos to do today, and I have to get to the gym. So later on, guys, see you later this afternoon.